Hey, it's attorney Mark Blane, working hard every single day for your personal injury cases here in San Diego, California. In this video, I want to talk to you quickly about Proposition 213. What is it and how does it affect your personal injury case? So let's get into it. Proposition 213 is a measure that was taken up by California in 1996 that basically says that if you don't have liability insurance and you get into a car crash that's not your fault, you can't collect pain and suffering damages, which is the biggest value driver on your personal injury case. Now, you can still get all the other damages you're normally entitled to if you had liability insurance, such as reasonable necessary wage loss, reasonable necessary medical bills, mileage to and from your doctor's visits, reasonable necessary property damage. You still get that, but if you don't have liability insurance, you'll be designated a Proposition 213 and you're absolutely barred for pain and suffering damages. It's just another reason why you want to make sure you have car insurance on your car every time you're out on the roadway, all right? And the reason why the lawmakers made it this way is because we didn't want to have rule breakers get a benefit. You know, a lot of law-abiding citizens are out there in California and they have liability insurance and they're protecting themselves with uninsured motorists and for those that they injure. But if you're driving on a California freeway and you don't have liability insurance, well, that's what the whole goal of Proposition 213 is. It's to mandate and punish those who are not responsible as opposed to other people out on the roadway. It makes sense. I mean, the rule of reciprocity is alive and well with it. So keep that in mind. And a lot of times I will still take a Prop 213 case. There's only two situations where I will. It's if there's other people in the car, because Proposition 213 only applies to the driver. So if there's passengers, that scrutiny does not apply to the passengers. The passengers can get all their damages, including pain and suffering. Just the driver, who's the Proposition 213, cannot. So I'll take a case and I'll have to manage the Proposition 213 driver to make sure that the medical bills get paid back, because they still get their medical bills, they just don't get pain and suffering. And then I'll take the passengers as well and help them with their case. So that's one exception as to why I would take a Prop 213 case. The other one is a little bit more rare. It happens when the driver is a Prop 213, but let's say they have a health plan, but the car crash was such that they have expensive ER medical bills, which happens. And then the health insurance lien is $30,000 in terms of what the health plan paid out for all the medical bills. And we all know medical bills can get expensive. So if there's a health plan involved and it's a Prop 213 driver, I might be able to reduce the health lien reimbursement provision to such a low level where it leaves a surplus of money available for that injured client. It's rare. I've done it before. I generally don't take Proposition 213 cases, and that should send a message to anyone watching this video. It's going to be hard to have a lawyer on your case if you don't have liability coverage because you're a Prop 213, because again, there's no pain and suffering to go after, which is the biggest value driver on your injury case. If you want to learn more about Proposition 213, its strategies on how I use it, feel free to call me up. You might be in a situation right now where you are a Proposition 213, and you might have a question on what I just talked about in terms of maybe helping you. So if that's you, feel free to reach out to me. I'll make myself available to you anytime, 24 hours a day, 7 days a week. You can find my contact anywhere here or social media. And with that said, I hope you have a great day, and as always, stay strong.